Welcome to the first in our new series of webinars focusing on rural property disputes. My name is Stephanie Hepburn. I am an associate in our property disputes team. I have particular experience in contentious rural property matters and have experience in the Sheriff Courts, Court of Session, as well as the Land Court and Lands Tribunal. With me is my colleague Hamish Lean, who is a partner in our rural property and business team based in our Aberdeen office. Hamish is widely recognised as one of Scotland's leading experts in rural law, and he regularly represents clients in the Land Court in contentious agricultural tenancy disputes and also in relation to subsidy appeals. In this first webinar, we'll have a look at some of the most common problems that arise from serving notices on agricultural leases and how these might be avoided. And at the end, we'll just look at some practical tips for landowners, tenants and their advisors. We are hoping to have 5 minutes at the end of the webinar to answer any questions you might have, so please do use the chat facility on your screen there to type in your questions, and we'll try and pick up one or two of these at the end. So to start us off then, Hamish, can you tell us a bit more about the statutes that regulate agricultural tenancies?
Yes, Stephanie, thanks very much. I suppose on one view, agricultural leases are simply a form of commercial property lease. But in fact, agricultural leases in Scotland are very closely regulated by statute. As a result, it will almost certainly be the case that when the need arises to serve a notice in an agricultural tenancy, whether by the landlord or the tenant, the governing rules will be found in the relevant statute rather than the lease itself. And the statutes which regulate agricultural tenancies are the Agricultural Holdings Scotland Act 1991, the Agricultural Holdings Scotland Act 2003 and the Land Reform Scotland Act 2016.
I know, Hamish, there's been a few new forms of tenancy created in the 2003 and 2016 Acts that you mentioned just there, but what's happened to the previous tenancies under the 1991 Act?
It's important, I think, to understand that as well as introducing new forms of tenancy, the 2003 and 2016 Acts also modified the rules which governed previously existing tenancies. For example, the 2003 Act, which introduced short limited duration tenancies and limited duration tenancies, also modified old-fashioned secure tenancies, which are regulated by the 1991 Act. And in a similar way, the 2016 Act, whilst it introduced the modern limited duration tenancy and repairing tenancies, it also modified secure tenancies under the 1991 Act and SLDTs and LDTs under the 2003 Act. The rules about repairing tenancies, however, aren't in force as yet.
So, where landlords, tenants and their advisors are thinking about service of a notice under an agricultural tenancy, it's important to identify which form of tenancy is actually being dealt with.
Yes, because the form of notice can depend on whether or not the tenancy is a secure tenancy, an SLDT, an LDT, a modern limited duration tenancy or a repairing tenancy. And once that's been established, it's necessary to check the relevant statute to find out what the rules are in relation to service of notices, but always remembering that those rules may themselves have been modified by succeeding acts.
Okay, so let's look at the types of situations where a landlord or tenant may require to serve a notice on the other party to the lease. Occasions like rent review or when a party wants to terminate the tenancy spring to mind, but what other circumstances might you find a notice is required?
Well, rent review and termination of tenancy are both circumstances where notices are required, but notices are required in a wide variety of circumstances, including making tenants or landlords improvements, diversification, resumption of land, waygoing and compensation claims at the end of a tenancy, removal of fixtures at the end of a tenancy, lifetime assignation by the tenant to a successor, succession after death, and statutory and conventional irritancies. Now, that's not a comprehensive list, And of course, it's beyond the scope of this webinar to look at every occasion on which a notice might be necessary. However, I think what we're hoping to do in the webinar is highlight some general rules that apply in relation to the service of notices and draw people's attention to the most commonly encountered situations where things can go wrong.
Well, being a litigator, we see this quite a lot in practice. Two of the most common problem areas that we see in respect of service of notices have to do with, firstly, identifying the parties correctly, and secondly, in relation to the time limits that have to be observed in relation to the service of a particular notice. And we're going to look at some of the problems that can arise in relation to these. Looking firstly at the identity of the parties, it might seem at first glance that it's obvious and the identity of the landlord and tenant will be easily ascertained. Hamish, is that right? Is there any guidance in the legislation that we need to be aware of?
Yes, in relation to secure tenancies governed by the 1991 Act, Section 84 of the Act provides that any notice or document which is required or authorised by or under the Act to be given or served on any person shall be duly given or served if it is delivered to him or left at his proper address or sent to him by registered post or recorded delivery.
So what happens then where the landlord or tenant's a company?
The section goes on to provide that where the other side is an incorporated company or body, the service address is the registered office of the company or the body.
What then about situations where a tenant is serving a notice and the ownership of the holding might have changed over the years? Is the tenant expected to be aware that ownership has changed or bear this in mind when they're serving the notice?
Well, once again, Section 84, subsection 4 has a part to play for secure tenancies regulated by the 1991 Act. What that provides is that unless or until a tenant has received a notice that the landlord has changed, the tenant is entitled to serve a notice on the original landlord, and that's deemed to be good service.
I think an example might help us. Do you have perhaps an example you could talk us through?
Well, yes. If you think about the situation where ownership of a farm might have changed hands within the landlord's family, perhaps by gift from one generation to the next generation, notices which the tenant serves on the old landlord will be perfectly valid unless the new landlord has given a notice to the tenant confirming that in fact they are the new landlord. And if that hasn't been done, then the new landlord might miss an opportunity to object to a notice by the tenant, perhaps to do with a tenant's improvement or in relation to assignation of the tenancy or perhaps a diversification activity. If the new tenant, or rather new landlord, doesn't receive the notice because they failed to tell the tenant that they are now the landlord, then they may well have missed rights to serve counter notices. The section, however, also has another flip side to it, which is it can operate to the tenant's disadvantage. When a tenancy is inherited from a deceased or from a deceased family member, there is a requirement by the successor tenant to serve a notice on the landlord, but the successor tenant isn't entitled to the protection of Section 84, so that if ownership has changed hands and the successor tenant isn't aware of that fact and serves a notice that they've acquired the tenancy on the old landlord, that won't be an effective notice and in some circumstances could lead to the end of the tenancy itself.
And these provisions in Section 84 apply to all types of agricultural tenancy?
No, only to secure tenancies regulated by the 1991 Act. There's no equivalent of Section 84 for SLDTs and LDTs and modern limited duration tenancies and repairing tenancies under the 2003 and 2016 Acts. So when a tenant is serving a notice in relation to one of those forms of tenancies, they will always have to make sure that they're serving the notice on the correct landlord.
And in relation to that point about the correct person on which to serve the notice then, can you serve a notice on the agent of the landlord or tenants?
Well, once again, this is a situation where there's a difference between secure tenants under the 1991 Act and other forms of tenancies. And that's because Section 85, subsection 1 of the 1991 Act provides that anything which by or under this Act is required or authorised to be done by, to or in respect of the landlord or the tenant of an agricultural holding may be done by, to or in respect of any agent of the landlord or the tenant. Now that's a very helpful provision when dealing with secure tenancies regulated by the 1991 Act.
So essentially what that provision does then is allow service of notices on agents of the landlord or tenant as opposed to directly on the landlord or tenant themselves.
That's absolutely correct. And there's quite an interesting land court case about Section 85, and that's Trustees of Ingersoll Firs against Calder, which is a case from 2010. Now, in that case, a father and son were joint tenants in a fully secure agricultural tenancy regulated by the 1991 Act. The father died, and the landlord's agent served a rent review notice on the executors of the late father and the son. The executors then transferred father's interest in the tenancy to the son, who then served a notice under Section 12 of the 1991 Act on the landlord's agents that he had acquired his father's share of the tenancy. The landlord then raised proceedings on the expiry of the first anniversary of father's death for declarator that the tenancy had come to an end because no valid transfer had taken place. They argued that the son's notice of acquisition was invalid because the agents had no authority to accept service of the notice. Now, the Land Court wasn't very much impressed by that because it held that service of a notice in terms of Section 85, subsection 5, could be on an agent, and that agent didn't need to have express, implied or ostensible authority to accept the notice. The key requirement for the purposes of Section 85 was that the agent was in fact an agent of the landlord in some capacity.
And these provisions in Section 85 then apply to all types of agricultural tenancy?
No, absolutely not. There's no equivalent of Section 85 in either the 2003 Act or the 2016 Act. And therefore, when notices are being served in relation to SLDTs and LDTs and MLDTs and repairing tenancies, they should only be served on agents when the person serving the notice has satisfied themselves that the agent actually has authority to accept service.
So in the absence of being able to establish that authority then, the only safe course of action is really to serve it directly on the landlord or the tenant then?
Yes, that's correct. And there's a good example of that in a Court of Session case, Balgrey Limited v William Hodgson, which dates from 2016. In that case, the Inner House of the Court of Session examined certain notification requirements under the 2003 Act, in particular on whom the notice which was required in that case, on which person that should be served and where it should be served. The crux of that case was that in serving a notice under Section 72(6) of the Agricultural Holdings Scotland Act 2003, which applies where the tenant is a limited partnership, on Balgrey Limited, Mr Hodgson's agents served the notice not on the company, but rather on a Mr Patterson, who was a director and company secretary of the company. The validity and effect of the notice was challenged by the company at the Scottish Land Court. Now, the Land Court took the view that the notice had been validly served, and that was on the basis that Mr Patterson was the directing mind and will of the company, and that Mr Patterson in the witness box had admitted to receiving the notice and understanding the contents of the notice and what it was meant to achieve. The Land Court decided, therefore, that the company had been given the required notice in time. The company appealed to the Court of Session, and the Court of Session took a much more restrictive view and decided that the notice, because it was addressed not to the company but to Mr. Patterson, the notice hadn't been served on the company.
So I think that case is quite a good example of where we see the courts interpreting the provisions in the statute quite strictly. Moving on then to where things can go wrong for both the landlord and tenant in relation to getting the dates of service of notices correctly. This is something I see in practice at least every other week, where a colleague comes and says to me, has this been validly served? Is the date correct? If we start then with fully secure agricultural tenancies, Hamish, can you give us some examples of problems that might arise?
Yes, there are common problems in relation to getting the dates of service of notices correct. An example is Section 21 of the 1991 Act, which entitles a landlord to serve a notice to quit on the tenant. Section 21 provides that the notice has got to be in writing, it must be a notice of intention to bring the tenancy to an end, and it must be given not less than 1 year and not more than 2 years before the contractual termination date. Where the lease is being continued by tacit relocation, the notice to quit must be given not less than 1 year and not more than 2 years before the anniversary of the tenancy. Now, tacit relocation is the Scots law rule whereby a lease is automatically continued for a period of 12 months from the contractual expiry date, where neither the landlord nor the tenant have taken steps to bring the tenancy to an end. Now, most secure agricultural tenancies entered into under the 1991 Act will have been granted many years ago. The original contractual term will have long expired, and they'll actually be continuing in tacit relocation from year to year.
So the effect then of Section 21 on a lease continuing by tacit relocation is that the notice to quit has to be served not more than 2 years and not less than 1 year before the anniversary of the original contractual expiry date. That's quite a mouthful. Can you perhaps give us an example that might help assist understand that provision?
Yes. Let's think of a lease where the set up for a period of 10 years in 1972. From the 28th of November of 1972, it'll run out on the 28th of November 1982. It will have been continued on a yearly basis from the 28th of November 1982 by the operation of tacit relocation. Now, in order to serve a competent notice to quit against that tenancy, the notice would have to be served on or before the 28th of November this year in order to terminate the lease as at the 28th of November 2019, because that's giving more than a year's notice but less than 2 years' notice. And that notice to quit will have to be in the tenant's hands on or before the 28th of November this year. Now, if it's being served by recorded delivery post, relying on the terms of Section 84 of the Act, a notice served by recorded delivery is presumed to have been received the day after it was posted. Therefore, service of a notice by recorded delivery on the 27th of November of this year would be presumed to have been received on the 28th of November.
And what about counter notices? I think a tenant can serve a counter notice.
Yes, where the protection for a tenant in a secure tenancy arises is by the operation of Section 22 of the 1991 Act. Now, what Section 22, subsection 1 does is allow the tenant, not later than 1 month from the giving of a notice to quit, to serve on the landlord a counter notice in writing requiring Section 22 to apply to the notice, which means that the notice to quit will not have effect unless the land court grants consent to the notice, and the circumstances in which the land court will grant consent to a notice to quit are really very, very limited indeed. Now, the important thing to notice here is that the section requires the tenant's notice to be served within 1 month of the giving of the notice to quit, not the date of its receipt.
So, going back to our hypothetical example then, if a tenant serves his or her counter notice, which is received by the landlord on 28th of December, in our example, being a month after the date that it's received, this wouldn't be a valid counter notice because it should have been received not later than 27th of December.
Yes, that's absolutely correct. Now, if we leave aside those limited circumstances where the landlord is entitled to serve a notice to quit, where the tenant doesn't have the capacity to serve a counter notice, an example of that would be where planning permission is obtained over the whole of the holding. Where the tenant has served a counter notice, Section 23 of the Act provides if the landlord wants to seek the land court's consent to the notice, an application must be lodged with the court within 1 month after service on the landlord by the tenant of the counter notice.
And this 1 month time limit runs from the...
The time limit of 1 month runs from the date of service, not the date of giving.
So going back to our hypothetical example then, where a tenant has served a counter notice on 27th December, the landlord has until 27th of January to make the application to the land court, being 1 month from the date of service.
That's absolutely right.
And what happens then, Hamish, if these time limits aren't observed?
Well, that's disaster, particularly disaster from the tenant's point of view, because if the tenant fails to serve a valid tenuous counter notice against a notice to quit, that will lead to the end of the tenancy. The tenant has nowhere to go. If the landlord fails to observe the time limits, then I suppose circumstances might not be quite so bad because the landlord can always start again. But if there's any urgency of bringing the tenancy to an end, they're put back by at least a year, possibly 2 years, depending on the timing. So the consequences can be grave.
The key message then is to seek legal advice from yourself at an early stage.
Never too early to call your solicitor.
Looking then at situations where an agricultural tenancy is being inherited, what sorts of things might go wrong there?
Now, this is one of the most common occasions when people, through a lack of proper understanding of the law and the lease, will get things wrong. There are two ways, essentially, in which a tenancy can be inherited. The first is where the deceased tenant has left a valid bequest in his or her will, passing the tenancy to a qualifying beneficiary. The second way is where there isn't a valid bequest, but the deceased tenant's executors have confirmed to the tenant's estate, including the interest in the tenancy, and have then made a formal transfer of that interest to a suitable qualifying beneficiary. In the case of a legatee under a bequest or an acquirer after a transfer by executors, the successor tenant has to serve a notice on the landlord that they are now the tenant in order to complete the process.
And do these rules apply to all types of agricultural tenancy?
Yes, they do. The rules are set out in sections 11 and 12 of the 1991 Act, as amended by the 2016 Act, and the 2016 Act then applies those rules to secure tenancies, short limited duration tenancies and limited duration tenancies under the 2003 Act, and modern limited duration tenancies and repairing tenancies under the 2016 Act.
So if we look at the case of a bequest of an interest in a tenancy, what rules must be complied with there?
In the case of the bequest of an interest in the tenancy, the legatee must give the landlord notice of the bequest within 21 days after the death of the tenant.
And is that different when an acquirer obtains a tenancy by transfer by the executors?
Yes, it is, because where an acquirer obtains a tenancy by transfer from the executors, the acquirer must give notice to the landlord within 21 days of the date of acquisition. However, it's important to be aware that in terms of Section 16 of the Succession Scotland Act 1964, the executors of a deceased tenant must confirm to the deceased's interest in the tenancy and make a transfer to the acquirer not later than the first anniversary of the tenant's death. So the time limits are more generous in those circumstances.
I think I've seen quite a few leases in times where it prohibits the tenant from making a bequest of his or her interest in the tenancy to a beneficiary. What happens in those circumstances?
Well, in fact, most written agricultural leases will prohibit the tenant from making a bequest to a beneficiary. Now, the lease won't say in terms that the tenant is prohibited, but it will exclude assignees as a common phrase, and the effect of that phrase is to exclude testamentary bequest. It follows from that where someone has made a formal bequest in their will and the successor serves a notice on the landlord within 21 days of the tenant's death, if the lease prohibits testamentary bequest, that notice is invalid because the deceased tenant wasn't entitled to leave their interest in the tenancy in their will. And that leaves aside any difficulties which might have arisen where the identity of the landlord has changed between the date of death and the service of the notice. The correct procedure, where the lease does prohibit the tenant from making a formal bequest, is for the tenant's interest to be dealt with as an item of intestate estate and to be confirmed to by the executors and transferred to the successor tenant. Confirmation must be obtained and the transfer must take place on or before the first anniversary of the tenant's death. The notice of acquisition must be given within 21 days of the acquisition taking place. I was recently involved in a case where a fully secured 1991 Act lease provided that the tenant wasn't entitled to leave the tenancy in their will. However, the tenant had made a will. The will had contained such a bequest. On the death of the tenant, the legatee served a notice on the landlord within 21 days of the date of death. The landlord took no action on receipt of that notice, didn't issue a rent invoice, no rent was paid, and after the first anniversary of the previous tenant's death, the landlord then demanded vacant possession of the farm. The reason for the demand was that the bequest of the tenancy was invalid, the notice accepting the bequest was incompetent, no steps had been taken to transfer the tenancy within the first anniversary of the death, and in that particular case, the tenant was obliged to give up vacant possession.
The key message then is vitally important when dealing with agricultural tenancies to understand the occasions when it's necessary to serve a notice on the other side and comply with the legislation, really.
Well, I think that's right. I mean, it's necessary to be sure about who you're actually serving the notice on and what the time limits are.
In terms of practical tips then, what tips can you offer our listeners to ensure things don't go wrong?
Well, I suppose the first and most important tip is, and I suppose our audience would expect me to say this, but it's never too early to consult your solicitor. But apart from that, there are obvious things to do. If you're drafting the notice, check it, and then when you've checked it, check it again, and then check it again after that. Make sure that if the notice requires to contain information, you've actually included all of the information. If the notice refers to documents, for example, an improvement notice will set out what the improvement is and how it's to be carried out and so on. Make sure that those documents are properly referred to. Make sure that you get the description of the lease correct, including any variations which might have taken place. Don't rely on historic evidence of ownership. Unless you're a tenant in a secure tenancy relying on Section 84, you've got to check who the up-to-date landlord is. Once again, check for errors and typos. Check the heading of your notice. Do searches in the Land Register and Company's House on the day of service if necessary. Double check there's been no material change as to the identity of the parties. For goodness sake, keep copies of any recorded delivery slips when you've served a notice. And, as always, if in doubt, seek legal advice.
Okay, thanks Hamish. That concludes our webinar on common disputes that arise from served by notices under agricultural leases. We've discussed some of the most common problems that can arise in relation to service, particularly in relation to the identity of the parties and the timings that must be adhered to. We've also offered some practical tips which on the face of it might seem obvious, but are often forgotten and often the subject of costly litigation. Before I talk myself out of a job, do we have any questions from anybody? No questions. Hamish, anything else you want to add?
No, I think that's that. Steph.
That's great. Thank you for joining us. Our next webinar is on ransom strips in rural land development, and I hope you can join us for that one. Thank you.
Goodbye.